Right. I believe that we're all here. Hello, everybody. My name is Dakshita. With me, I have my co-moderator, Fariha. It's a very warm afternoon slash evening here in India. So good evening. I believe that everybody is here so we can begin with the session with the arbitrator's permission. Um, Respected arbitrators, over to you.
Thank you. Now, I'm on an iPhone, so I can only see a couple of people at once. So I'm looking for, okay, I now see some oralists. Would the claimant please tell me the names of your oralists and which role you are playing, please?
Good afternoon. Good afternoon. I am Francesca D'Argenio, and I will be addressing substantive issues of contract formation. And my co-counsel is Catherine Arnold, who will be addressing jurisdictional issues.
And what order are you you are the claimant or the respondent?
We are the claimant, and we have conferred with. We've conferred with the respondent, and the order we have decided is that we will begin with the claimant putting forward a positive case on contract formation, followed by the respondent replying, and then the respondent beginning on jurisdictional issues with the claimant replying.
So you're doing it in that order. You're doing the jurisdiction secondly.
That's correct.
And the substance first.
Yes.
Okay. And so we have Francesca on the substance and Catherine on the jurisdiction. Is that right? And
that's correct.
For the respondent?
My name is Anjali, and I will be addressing the substantive issues on behalf of the respondent. My co-counsel Smriti will be dealing with the procedural issues.
Sorry, so it's Anjali on the substance.
Yes.
And what is the name of the jurisdictional?
Smriti.
And this, sorry?
Smriti, S-M-R-I-T-I.
Smithy.
Yes, Smriti.
Okay, Smithy. Okay. So do you have does anyone have anything they would like to discuss quickly before? What about timing? What about 15 minutes each, is it?
Yes, 14 minutes for the submissions and 1 minute will be reserved for rebuttals or surrebuttals.
14 plus 1, okay. Any other points or questions you wanted to ask us before you start? Let me just introduce the other arbitrators. We have Sundaraju and Patricia. Oh dear, I don't have everybody's full name. There's Patricia and Sundra and Tejas and Stephen. So you will meet them when they speak, I guess. All right, well, please, and we have a timekeeper, so they will tell you how much time you have. So why don't we start? Please go ahead.
Thank you very much, and good afternoon, members of the tribunal. My name is Francesca D'Argenio, and I appear as co-counsel on behalf of the claimant in this matter, that is LGUP PLC, who is the seller. I will be speaking on matters of contract formation, addressing questions 1B and C of procedural order number 1. And I will be speaking for 14 minutes, reserving 1 minute for rebuttal and surrebuttal. It is our submission that the parties validly concluded a contract in 2020, and furthermore, that the claimant's general conditions of sale were validly included into that contract. Before speaking substantively on either point, I will be addressing an issue that is pertinent to both, and that is our submission that Ms. Bupati's knowledge of the previous practice between herself and Mr. Chandra should be imputed to, and therefore binding upon, the respondent. And we put forward 3 reasons why the tribunal should accept this proposal. Firstly, in his commentary to the CISG, Schwenzer argues that under Article 79, a company is liable for all persons that it engages to perform its duty under contracts, and any relevant knowledge acquired by persons who are thus employed can therefore be imputed to their principal. Secondly, when this previous practice was established, Miss Party was acting as an agent for Southern Commodities, that is the respondent's parent company. Now, courts in the United States have recognized that where the same individual acts for both a parent company and its fully owned subsidiary, knowledge which it acquired acting for one affiliate can be imputed to the other. And the case I'm referring to there is Northern Natural Gas of Omaha and Superior Court in the Appeal Court of California. And thirdly, this practice was central to Miss Party's role in this transaction. If you would turn please to page 31 of the record, which is Exhibit R3, and turn to paragraph 4. Now, if the tribunal are with me, you will see in paragraph 4, I'll read to you that Miss Party says her experience in the palm kernel oil market and her resulting connections to producers was one of the reasons why she was offered the position as head of purchase at Jar Jar Biofuel. She then goes on in her email of the 1st of April, which is page 12 of the record, to say that she would like to re-establish her long-lasting and successful business relationship with Mr. Chandra while in her new function, thus making this previous practice fundamental to this contract. And for these reasons, Miss Party's knowledge of her practice with Mr. Chandra should be imputed to and therefore binding on the respondent. Now,
if I may ask a quick question, is the only party you've got for both the affiliation role and her conduct being binding on, or her knowledge being binding on the company, this one California state court case that you've given us?
Yes, that's our principal authority for this proposition.
And why should we think that is applicable at all to this matter?
First of all, it was a bit, so this is an issue of agency, and this is not something dealt with explicitly in the CISG. And it was a bit difficult to locate some case law for Equatoriana and Danubia. And therefore, we believe that taking an international approach to this issue is the second best option and the best one we have available to us. And so we look to international cases such as this one in California for our most persuasive authorities. I hope that answers your question, Mr. Arbitrator.
Thank you.
Thank you. So turning to my first argument as to contract conclusion, I will be making 3 submissions under this heading. Firstly, that the respondent made a valid offer in their email of the 1st of April, which was then accepted by the claimant on the 9th of April. And secondly, in the alternative, we submit that the claimant's email of the 9th of April could be construed as a counteroffer, and in which case it was accepted by the respondent by their conduct in performing substantive steps towards the performance of the contract. And thirdly, we submit that due to the binding previous practice between Miss Party and Mr. Chandra, the respondent's conduct subsequent to the claimant's counteroffer can be construed as acceptance. So turning to our first point, if the tribunal would please turn to page 12 of the record, which is Exhibit C2. So the parties are in agreement that this issue is conclusively governed by the CISG, and therefore we will be using principles of the CISG to determine whether a contract has been formed. And we submit that this email fulfills the requirements under Article 14 of the CISG for a valid offer. These are threefold. Firstly, that an offer must be addressed to one or more specific persons. Secondly, it must be sufficiently definite. And thirdly, it must indicate the intention of the offeror to be bound by acceptance. The first of these is easily satisfied. The second, in order for an offer to be sufficiently definite, it must contain specifications as to goods, their quantity, and their price under the contract. And if you will turn to the third paragraph in this email, you'll clearly see the details given for the 20,000 tons of RSPCO certified palm oil and its installments, its price, and its quantity. So that satisfies the second requirement. And turning to the third requirement, the respondent's intention to be bound. Throughout this email, the text of the email can be construed objectively to evidence an intention to be bound. The subject line is purchase offer, and the email contains the phrases, "I would like to place the following order with you," and Ms. Fauconnier will take care of the implementation of the contract and further discussions, if any, thus demonstrating that the respondent did not intend necessarily for there to be any further discussions, but was happy at this point to put forward an offer. And we submit that this was then accepted by the claimant's email of the 9th of April, which is page 17 of the bundle. If the tribunal would please turn to that. Under the CISG, a contract is concluded at the moment when acceptance of an offer becomes effective, irrespective of the party's intentions, per Article 23. And a statement made by the offeree indicating assent to an offer is acceptance for these purposes, under Article 18.1. In the body of this email, Mr. Rain clearly states, I've inserted the terms of your offer into the contract, which we accept. And thus this can be construed as an acceptance of the email of the 1st of April. Now, turning to our second submission.
Uncle, I had one question. In this email, it clearly says that I have sent you 2 signed versions of the contract document, and could I sign one copy back? So there was an understanding between your client and the respondent that it was always subject to entering into the formal agreement. And how do you come out of that? Because even if it was an acceptance, was it a counter proposal or it was a concluded contract? I'm just grappling with this. If you can help me with understanding that condition which you have put in your own email.
Of course, specifically as to the issue of signing the contract. As part of the previous practice between Mr. Chandra and Ms. Bupati, on 5 occasions, contracts had been performed without signature. In fact, without the contractual documents even being returned. This is evidenced on page 9 of the bundle, which is Exhibit C1. So also, as Mr. Rain makes clear in his email of the 9th, the signing of the contractual documents is, from his perspective, an administrative task and not one that is central to the formation of the contract. And furthermore, there is no formal requirement under the CISG for contract formation. And so the lack of a signature on behalf of the respondent is not fatal to formation. I hope that answers your question, Mr. Arbitrator.
Yes, thanks.
Thank you.
Wasn't that history when it was a different company, however, not the same company, although the same person?
Indeed, it was a different company. And we submit that for 3 reasons that this should be held, this history should be held to apply in the present case. Firstly, due to comments made by Schwenzer in his commentary on Article 79 of the CISG, stating that companies are held to be bound by the knowledge of their agents in performing contracts. And so the respondent would be held to be bound by Ms. Bupati's knowledge. Secondly, the fact that Southern Commodities, which is the previous company she worked for, is a parent company of Jar Jar Biofuel. And this has been held particularly in the American case that I mentioned previously, the Omaha case, to be binding. And thirdly, Ms. Bupati herself made this previous practice relevant to the issue at stake. And it seems to go against the good faith character of the CISG to allow the respondent to so manifestly make this important and then withdraw their reliance on this previous practice when it suited them. I hope that answers your question, Madam Arbitrator.
Yes, thank you.
Thank you. So turning to my final submission under the heading of contract conclusion, that is, in fact, that the respondent's conduct can be regarded as acceptance due to this previous practice. It is Article 9.1 of the CISG that provides parties are bound by established practices. And Article 18.3 of the CISG states that conduct can constitute effective acceptance, even if the offeror is not notified of this conduct. We submit that the respondent is bound by this established practice, and particularly by their conduct in opening a letter of credit or making inquiries to do so pursuant to Clause 7A of the contractual documents. In their previous practice, a letter of credit was opened in all cases, including in the cases where no contractual documents were returned. This was therefore a repeated part of the previous practice between Ms. Bupati and Mr. Chandra. And when Ms. Bupati neither signed nor returned the contract, the claimant relied in good faith on the fact that this was a signal of the respondent's acceptance based on this practice. And this marks the end of my submissions on the first point, that a contract was validly concluded. So unless I can be of any further assistance to the tribunal on this matter, I will turn to our second point. and that is that the claimant's general conditions were validly
Go ahead.
included. Thank you, Madam Arbitrator. Our second submission, that the claimant's general conditions were validly included by reference. And I'll be making two submissions under this heading. Firstly, that the claimant's inclusion of their general conditions of sale fulfills the established requirements for valid inclusion by reference. And secondly, even regardless of this attempted inclusion, the claimant's general conditions would have been included impliedly because of the previous practice that we have already submitted is binding. Now, firstly, although the CISG contains no express provision for the inclusion of standard terms, it has been held conclusively by academic commentary and case law that this is a matter governed by the CISG's principles on contract formation. And in particular, two requirements have emerged from this case law, which are stated in the CISG's Advisory Council Opinion number 13. And these are that the party wishing to include their standard terms must provide sufficient notice of their intention to do so, and that the other party must have a reasonable opportunity to take notice of the content of these terms. Now, the first point, turning to, again, page 17 of the bundle, multiple references to the standard terms make the claimant's intention to include their standard terms abundantly obvious. For example, the statement that on paragraph 3, the claimant's general conditions of sale apply to issues not regulated in the attached document. And this is in fact reiterated in the contractual documents transmitted to the respondent. The second requirement, that the respondent needed sufficient notice of the content of the terms. Article 3.4 of opinion number 13 on the CISG states that this can occur when parties have had prior agreements subject to the same terms. Now, Mr. Chandra and Southern Commodities via Mispi Party had eight prior agreements subject to these terms. The only difference is that this current agreement was subject to the law of Mediterraneo, but this change was, Mispi Party was informed of this alteration. And as such, as the respondent via its agent Mispi Party was previously bound by the same terms, they can be held to have had a sufficient opportunity to take notice of their content. Now, in brief, as I see I'm reaching the end of my time, I will argue that even regardless of the claimant's attempt to include their standard terms, this previous practice would include them by implication, because throughout the history of this practice, the claimant's general conditions of sale were always included by reference rather than transmission, as is the case at present. This is a consistent feature of these previous dealings, and they are thus validly incorporated. So unless I can be of any further assistance, this marks the end of my submission.
Very short question that, did you ever send this general conditions copy of that to the respondent?
Thank you, yes. At the very beginning of the business relationship between Mr. Chandra and Mispi Party, a copy had been sent. Revisions were made to the general conditions of sale in 2016, and no one can positively exclude that a copy was sent to Mispi Party. However, it is uncontested that Mispi Party was informed via the telephone of the change in these conditions. And as there's no requirement for form in the CISG, her having been orally informed of this change is sufficient for the standard terms to have been included. I hope that answers your question.
Yes, thank you.
Isn't the importance of the general condition that there was an arbitration clause, that the parties agreed that if they had a dispute, it would be settled by arbitration? But has that ever been discussed? Is there any proof that the parties actually agreed? Because we need to know whether we have jurisdiction to decide this issue or not. And that depends on whether the parties did agree to arbitration, not whether they agreed to the sale.
Absolutely, Madam President. And the existence of the arbitration clause is something that had happened in all of the it was included in all of the previous contracts between Mr. Chandra and Mispi Party. So there had always been an arbitration clause that was binding upon their previous contracts, firstly. The fact that the respondent also intended to submit the matter or any potential disputes to arbitration can be seen in Mispi Party's email of the 1st of April. Although she says she would prefer perhaps not to arbitrate, she says that nevertheless she would be willing to arbitrate, and indeed demonstrates her familiarity with the claimant's previous model of their previous arbitration clause. And she says she would prefer a non-industry related arbitral institution, which is in fact what the claimant provided her with. And so there is clearly some intent to arbitrate. on the part of the respondent as well as the claimant.
Good, thank you.
Thank you. Unless I can be of any further assistance, that marks the end of my submissions. Thank you.
I keep getting cut out, so I don't know if you can hear me, but I can't hear anyone at this moment.
Madam President, with your permission, if I may begin with my submissions. Am I audible?
Yes.
Sorry, I can hear now. Okay, I'm back. I keep getting cut out.
Madam President.
Maybe we can give a couple of moments.
All right, am I back online? They just keeps dying.
Yes.
All right, so are we about ready to hear the respondent?
Yes.
Sorry, I got lost for a moment. Okay. Please go ahead then. Hopefully I won't get lost again.
Thank you, Madam President. Members of the tribunal, greetings of the day. My name is Anjali Bhaskar, and I will be addressing the merits of this dispute on behalf of the respondent. The opposing counsel in her submissions has stated that the respondent is attempting to evade its obligations by denying the existence of a contract. However, as a matter of fact, it is the claimant who is attempting to impose obligations on the respondent that it had never agreed to in the first place. First, by turning ongoing negotiations into an already concluded contract, and second, by attempting to include its general conditions of sale that were never provided to the respondent and contained contradictory terms. To contradict the submissions made by the opposing counsels, I will be making 2 points. First, that the parties did not conclude a contract in April 2020. And second, that the claimant's general conditions of sale were not validly incorporated. However, before I proceed with the first submission, I would address the submission made by my opposing counsel regarding the fact that previously established practices between the claimant and Southern Commodities should be continued in the present case. Members of the tribunal, this position that the claimant adopts herein is incorrect due to 3 reasons. First and foremost, it must be noted that even though the respondent was acquired by Southern Commodities, it is a separate legal entity and handles the palm oil business without any interference from the Southern Commodities. Additionally, in the present case, this is the first instance of any legal relationship between the claimant and the respondent. The second point is that the opposing counsel placed extreme reliance on Ms. Bhupati's knowledge of the previous practice. However, if I may direct this tribunal to page 12 of the record. Page 12 of the record contains the email of 1st April, which was sent by Ms. Claire Bhupati to the claimant. If the tribunal would note paragraph 6 of this email, the last line. Here in this line, Ms. Bhupati has requested for a non-industry related arbitration institution. Even though the claimant's general conditions of sale already provided for a non-industry based arbitral institution, Ms. Bhupati, while placing the offer, has specifically requested for it. This shows that Ms. Bhupati did not have actual knowledge of the contents of the general conditions at the time of conclusion or at the time of the formation of this contract. And therefore, her knowledge, which did not exist at the time, cannot be imputed to the respondent. Turning to my third point, it must be noted that members of tribunal that Ms. Bhupati, through both statement and conduct, had communicated that she did not intend to continue any previously established practices. At the Palm Oil Summit, Ms. Bhupati had notified Mr. Chandra that the respondent works at a different political and commercial environment compared to the Southern commodities. Additionally, not following the previous practice wherein she would herself place an offer without consultation from the higher management, in the present case, she had to consult the management of the respondent company to make sure that by entering into a contract, she wouldn't go against the business policy. These instances indicate that Ms. Bhupati did not intend to continue the lenient practices that were established between the claimant and Southern commodities, where the contracts would be concluded without much negotiations. Now,
I
turning
have one question, Ms. Counsel, is that before sending the email of 1st April 2020, did Ms. Bhupati took the consultation from the management?
Yes, Mr. Arbitrator, at the Palm Oil Summit, Ms. Bhupati had communicated that she would have to consult the higher management, and only after that she would get back to the claimant within 3 days. And the same was done. This was contrary to the previous practice, where Ms. Bhupati would herself, without any consultation, place a purchase order.
So what do you mean by the email of 1st April? Was it an offer or an acceptance?
Mr. Arbitrator, our position herein is that the email of 1st April was a legally binding offer. However, we submit that the reply to this email, that is the email of 9th April, provided on page 17, was not a legally binding acceptance. If I may direct the tribunal to page 17 of the record, that is the email of 9th April. The opposing counsel has submitted herein that this email constitutes a legally binding acceptance because it indicates assent to the offer made by the claimant. However, what the opposing counsel seems to have overlooked is that acceptance under Article 18 must be unqualified, such that it is a mirror image of the initial offer. If the tribunal may now refer to page 13 of the record, page 13 of the record is a reproduction of the contract documents that were sent along with the email of 9th April. The tribunal would note herein that only the preamble of this contract contained a mirror image of the offer made by the respondent. On the other hand, 8 additional clauses were added to the contract template, which was not present in the respondent's original offer. Instances such as these, where parties modify, add or limit the terms of the offer while indicating acceptance, are dealt under Article 19 of the CISG. As per Article 19 of the CISG, if any modifications or alterations are material, then the same is a rejection of the offer and constitutes a counteroffer. It is our submission that by proposing to include its general conditions of sale to the present contract, the claimant had made a counteroffer. Members of the tribunal, the general conditions of sale contained 2 clauses. Clause 4, am I audible? Okay, I'm sorry, I think I got cut in the middle. Clause 4 of the general conditions limits the respondent's right to terminate a contract, and clause 9 of the general conditions provides a dispute settlement clause. It must be noted that Article 19, clause 3 of the CISG indicates that any changes made to liability clauses or dispute settlement clauses are material in nature. Therefore, by proposing to include its contract template, including the general conditions, the claimant had made a counteroffer that was then open for the respondent to accept.
If I can ask on that point, what was different? You're referring to a material change by providing a reference to the general conditions and the arbitration clause there, but was that different from what the parties had discussed? So is it a change or just a memorialization?
Mr. Arbitrator, it was indeed a change. Clause 4 of the general conditions restricted the respondent's right to terminate.
I heard that, but I was asking you about the arbitration clause.
Addressing the question on the arbitration clause, while the parties did discuss whether arbitration should be considered at the Palm Oil Summit, the particulars relating to the seat of arbitration, the law governing the arbitration agreement or the procedural rules that would be applied were not discussed at the Palm Oil Summit. Furthermore, in the offer that Ms. Bhupati made, provided on page 12, these indications were also not provided. Therefore, the parties at no point had negotiated the particulars of the arbitration agreement. Thus, by proposing to include the general conditions of sale consisting of Article 9, the claimant did make a counteroffer. Turning to my next submission, that this counter.
Ms. Anjali, can I ask a question? Earlier they have actually concluded 40 contracts. Will that count as established practice? Because parties have been in the course of dealing. Can you answer that, please?
Yes, Mr. Arbitrator. While we do not dispute that there were established practices between the claimant and Southern Commodities, what our submission here is that such practices cannot be extended to the present contract due to two reasons. First, the respondent is a separate legal entity that functions without any interference of Southern Commodities. And second, Ms. Bhupati, as previously mentioned, had communicated through both statement and conduct that she does not wish to continue any practices. A primary component of Article 9 Clause 1 of the CISG relating to established practice is that there must be intention to continue the same. It is our submission that in the present case, there was no intention to continue any previously established practices. Turning to my second submission, that the counteroffer was not accepted. Members of the tribunal, it must be noted that at no point after receiving the contract documents did the respondent communicate its assent through a statement, conduct, or by returning a signed copy. Instead, the very next instance of communication, which was on 3rd May, as provided on page 31 of page 30 of the record. If the tribunal is with me, paragraph 3 of this email shows that Ms. Faulkner had raised certain concerns pertaining to the contract documents. It is our submission that this particular email, as well as Ms. Faulkner's proposal to negotiate open issues in person, indicated that the parties were indeed in the negotiation stage and a contract had not been concluded. Turning to the second submission regarding the inclusion of claimant's general conditions of sale. The opposing counsel has again herein relied on previously established practice to state that the respondent had reasonable opportunity to take notice of the terms. However, members of the tribunal, we make 2 points to state that any previous established practice cannot be continued with specific reference to the general conditions. First, the tribunal must note that there were 2 different versions of the general conditions of sale. First, that is the pre-2016 version, and second, the post-2016 version. While we do acknowledge that the pre-2016 version was included in the first contract by providing a copy in 2011, for the post-2016 version, no copy was provided at the first instance. As noted by the CISG Advisory Council in its opinion 13, as well as the German Supreme Court in its decision in the machinery case of 2001, making the copy of standard terms available at the first instance is required for valid incorporation. Therefore, in 2016, when a copy was not provided, the new amended version was never validly incorporated at the very first instance to even give rise to any established practice. Furthermore, members of the tribunal, to have reasonable opportunity to take notice, Ms. Bhupati should have had actual knowledge of the contents of the general conditions. As previously mentioned, while making the purchase offer provided on page 12 of the record, Ms. Bhupati did not remember that there was an amended arbitration agreement which had already catered to her concern. This indicates that she did not have actual knowledge of the contents of the general conditions, such that her knowledge could be imputed to the respondent in the present case. What also must be noted is that in addition, while we do not dispute that the claimant did make its intention to include the general conditions clear, the respondent at no point communicated its assent to the same. Therefore, as in the present case, the respondent did not have a reasonable opportunity to take notice of the terms and did not accept the inclusion of the general conditions through mere reference, it is our submission that the general conditions of sale were not validly included.
What is your, sorry to interrupt, what is your stand on the discussion regarding the performance of contract by opening LC?
Madam President, I do note that I am about to exhaust my time. If I may get additional 1 minute to answer Mr. Arbitrator's question and conclude.
Yes, I think we can give you 1 more minute.
Thank you, Madam President. Mr. Arbitrator, what must be noted that in the email of 3rd May, Ms. Faulkner had merely sought clarification on the number of banks that could be accepted under the contract. At no point did she actually open an irrevocable letter of credit such that the contract could be performed. What must also be noted is that even in instances where Ms. Bhupati did not return a signed copy, a letter of credit was indeed open. Therefore, in all instances, the acceptance was communicated either through statement that was returning a signed copy or through conduct, that is by opening a letter of credit. In the present case, no letter of credit was open, but only clarification on a contract term proposed by the claimant was sought. Therefore, the respondent at no instance communicated its assent to the counteroffer made by the claimant. If I can be of no further assistance to this tribunal, I will now conclude and summarize.
Please go ahead.
Thank you, Madam President. To conclude and summarize, we request this tribunal to find that the parties did not conclude a contract in April 2020, and in any event, the claimant's general conditions of sale were not validly included. Thank you, Madam President. Thank you, members of the tribunal.
Thank you. Does the claimant have a rebuttal?
Yes, Madam President, if I may have 1 minute for my rebuttal. I will be making, thank you. I'll be making 3 main points briefly. Firstly, as to the respondent's argument that Ms. Bhupati did not have positive knowledge of the revised version of the 2016 General Conditions of Sale, it is undisputed that she was informed of this change to the General Conditions of Sale. And as there are no, form requirements under the CISG, an oral conversation is sufficient, and the claimant cannot be held responsible for Ms. Bhupati's forgetfulness in terms of this change. Secondly, as to the respondent's argument that the addition of the arbitration clause is a materially altering term under 19.3 of the CISG. Firstly, it is in line with what Ms. Bhupati requested in her email of the 1st of April, in all points other than the inclusion of transparency rules under the UNCITRAL transparency rules. However, these only apply to treaty-based investor-state arbitrations, and so their mention, as it was erroneous, cannot be said to be fatal to contract formation. And in fact, Schwenzer, in his commentary to Article 19 of the CISG, says that in practice, such a clause is never allowed to prevent contract formation. I have 1 more brief submission to make, if I may, Madam Arbitrator. I see my minute is over.
Yes, please, go ahead.
Thank you.
Go ahead.
Thank you. Simply to address the point that the letter of credit does not constitute sufficient performance. In fact, communicating this request to the claimant allowed the claimant in good faith to believe that the contract would be performed per previous practice. And in fact, the respondent knew that the claimant was in desperate need of a buyer, and so the claimant relied on this to their detriment. That marks the end of my submissions.
Thank you. Does the respondent have a rebuttal?
Yes, Madam President, we'll be addressing the first and the third concern raised by the opposing counsel regarding the positive knowledge that Ms. Bhupati had and the opening of letter of credit. Members of the tribunal, the opposing counsel seems to have overlooked that even during the negotiations at the Palm Oil Summit, Ms. Bhupati did inform Mr. Chandra that certain legal terms of the contract would have to be adapted to suit the respondent's changing commercial and political environment. Therefore, Ms. Bhupati had communicated that the legal terms would further be discussed and not accepted without discussion as followed in the contracts with Southern Commodities. relating to letter of credit. Here, I would cite the case of Macallan International Corporation versus Salzgitter Händel. In this case, it was noted that only an opening of an unrevocable letter of credit would performance constitute conduct indicating assent. In the present case, only clarifications were sought and there was no performance that was carried out. Thank you, Madam President. Thank you, members of the tribunal.
Thank you. Does any of the other arbitrators have any questions on this first section?
Not from my side. Thank you.
Okay, well, we might as well move ahead to the second section. Does the respondent go first on this, or is this, I can't remember, or is the claimant also leading?
Yes, Madam President. I'm the counsel for the respondent and I will be going first.
Okay, please go ahead.
Indeed, Madam President. Madam President and members of the tribunal, greetings of the day. I am Smriti Ramakrishnan and I am the counsel on behalf of the respondent, Jaja Biofuel, for issue A, that is the procedural issue in the instant dispute. To provide a brief background of the proceedings with respect to the procedural issue, on 15th July 2021, the claimant Elga PLC filed a commencement request and a notice of arbitration against the respondent for its alleged failure to fulfill the terms of the contract for palm and palm kernel oil products. In this regard, the claimant invoked Article 9 of its General Conditions of Sale as provided in page 32 of the record, which provides the arbitration agreement. However, it is the respondent's position that the claimant invoked this arbitration agreement on its own, for its own benefit and without the consent of the respondent. Therefore, it is our submission that this arbitration agreement was not validly concluded under the relevant laws, and that as a result, this tribunal does not have the jurisdiction to hear the present dispute. For this purpose, the respondent will be making three broad submissions. First, that it is the law of Mediterranean that governs the arbitration agreement. Second, that the CISG is applicable over the arbitration agreement. And third, that the arbitration agreement was not validly concluded. Proceeding to my first submission, that it is the law of Mediterranean that governs the arbitration agreement. Preliminarily, it is pertinent to highlight that there exists a three-step test as enumerated in Article 5, Paragraph 1, Subparagraph A of the New York Convention, as well as in Article 36, Para 1, Subpara A, Point 1 of the Untitled Model Law on International Commercial Arbitration. According to this three-step test, which is used to determine the law governing the arbitration agreement, the first step is to determine whether the parties made an express choice of law to govern the agreement. If this does not exist, then the tribunal should look into whether the parties had agreed upon an implied choice of law to govern the arbitration agreement. And last, upon non-existence of an express or implied choice of law, this tribunal has, yes, Madam Arbitrator.
Yes, I would like you to, you have referred to the New York Convention and to the Danubian arbitration law, I assume, or the model law.
Indeed, Madam Arbitrator.
But I assume that you are referring to the model law in its implementation to Danubia, or are you referring to it as Mediterranean law?
Madam Arbitrator, the Untitled Model Law was adopted by both Danubia and Mediterranean, except that Danubia adopted option 1 of Article 7 and Mediterranean adopted Article 2.
Yes, and so that was the first question is, which of these are you actually referring to? And more specifically, where can you identify that the New York Convention or the model law provision, which you're referring to, provides that an agreement which is implied by the parties would lead to the applicable law?
Indeed, Madam Arbitrator. While we agree and acknowledge that the present arbitration agreement referred to a choice of law clause, which was not actually implemented in writing in the arbitration agreement, the ancestral model law under option 2, I apologize for the background. Am I audible? Thank you, members of the tribunal. Under option 2 of the ancestral model law, it must be noted that the definition for an arbitration agreement does not require it to be in writing. Therefore, we rely on the mutual agreement between the parties that it is the law of Mediterranean that should govern the contract as a whole, in order to submit that this law of Mediterranean must also govern the arbitration agreement. If I have clarified your question, Madam Arbitrator.
Yes, but just one follow-up. You indicated there's a 3-step test under Article 5 of the New York Convention and under the model law. And you said that the second step was that there is, and if there is not a formal agreement, then an applied agreement would lead to that. And I wonder, where do you get this 3-step test? Does the law actually provide that, or are you relying upon authorities that interpret it?
Indeed, Madam Arbitrator, we rely on the wordings of Article 5, Para 1, Subparagraph A of the New York Convention, as well as Article 36, 1AI of the ancestral model law, which states, if I may quote the New York Convention, states that the parties to the agreement referred to in Article 2 were under the law applicable to them under some incapacity, which is the first part of the New York Convention provision I am citing, or the said agreement is not valid under the law to which the parties have subjected it, which is the express choice of law. And the next part, which states failing any indication thereon that looks into the intention of the parties, therefore falling within the implied choice of law bracket. And lastly, under the law of the country where the award was made, which our submission is that this tribunal has the power under Article 13.5, Paragraph A of the EIAC rules to determine what it considers most appropriate. If I have clarified your question, Madam Arbitrator. Thank you. If I may proceed with my submission, that is, it is our position that under this 3-step test, the law of Mediterranean was the implied choice of the parties, thereby satisfying the second step under the 3-step test. It is our position that according to this test, the law of Mediterranean was the implied choice, since we must look into the intentions of the parties to ensure that their contract, the substantive part of the contract, as well as the arbitration agreement, are governed by the same system of law. We base this on the submission that the arbitration agreement forms part of the contract itself. This was also highlighted by the United Kingdom Supreme Court in the case of Enka versus Chubb, wherein in paragraph 170.4, it was held that where there does not exist an express choice of law specifically for the arbitration agreement, the express choice provided for the contract as a whole must also be the law to govern the arbitration agreement. Therefore, in the present case, since the choice of law clause stipulates that this contract shall be governed by the law of the state, it is a natural inference that the parties intended for the whole contract, including the arbitration agreement, to be governed by the law of Mediterranean. Further, we also submit that the parties did not intend to apply the law of Danubia to govern the arbitration agreement. We rely on the parties' implicit negative choice, which is that firstly, they did not provide a separate law itself to govern the arbitration agreement, and secondly, that nowhere in the factual matrix of the case provided in the record did the parties provide their intention to apply the law of Danubia to govern the arbitration agreement. Therefore, to conclude this submission, it is our position that the law governing the arbitration agreement is not the law of Danubia, but the law of Mediterranean. Proceeding with my second submission, which is that the CISG is applicable over the arbitration agreement. Preliminarily, it is pertinent to note that Mediterranean is a contracting state to the CISG, and therefore, under Article 1, Para 1, subparagraph B of the CISG is automatically applicable over the arbitration agreement. However, we further submit that an arbitration agreement also falls within the scope of the CISG under Article 4 of the CISG. While it is true that Article 4, the list provided in Article 4, which is namely transfer of property and validity of contract, while we agree that this list is not exhaustive in nature, we rely on Professor Dr. Schlechtje, who stated that it is vital to interpret the CISG as a convention as a whole, and therefore that we need to look into other provisions of the CISG to determine whether dispute resolution clauses fall within its scope. In this regard, we rely on Article 19 of the CISG, which provides that an alteration of the arbitration clause shall constitute a material alteration of an offer under the CISG, as well as Article 81, which provides that the arbitration clause shall continue even upon avoidance of the contract under the CISG. Furthermore, we also rely on the German Federal Court's case decided in the year 2020, which is the Mayflower decision, in which the court held that if an arbitration agreement is not considered part of the CISG, then articles and provisions of the CISG, such as Articles 19 and 81, will be considered superfluous. Therefore, to conclude this submission, it is our position that the CISG is applicable over arbitration agreements generally, and therefore also over the present arbitration agreement. Moving on to my last submission, which is that the arbitration agreement was not validly concluded under the law of Mediterranean. Mediterranean follows the CISG. Mediterranean law follows the CISG as well as the UPICC, and also follows the UNCITRAL model law, specifically Article 7, Option 2. Therefore, all the laws of Mediterranean require an agreement to be validly concluded only if there existed a common intention or meeting of minds between the parties. This can be determined based on statements made by the parties, their conduct, or established practice between the parties. We have two factual points to highlight that indicate that there existed no meeting of minds between the parties with respect to which arbitration agreement was to be applied to the present contract. First is that Ms. Fauconnier, who was the assistant of Ms. Bhupati and a representative of the respondent, was as provided in procedural order number 2 in page 52 of the record. In paragraph 25, it had been mentioned that Ms. Fauconnier, while communicating with Mr. Rain, the representative of the claimant, she was under the impression that it was the pre-2016 arbitration agreement dealing with the phosphor param model of arbitration that was to be applied to the present dispute. The second factual point is that when Mr. Rain replied to Ms. Fauconnier, he did not bother correcting her and only corrected her with respect to non-applicability of the UNCITRAL rules. And while he knew that she was under the impression that it was the phosphor param model that was to be applied, Mr. Rain did not correct her and show in any manner that it was the AIAC rules that was to be applied. Therefore, it is our position that at no point during the negotiation process between the claimant and respondent was there any meeting of minds or common intention with respect to which arbitration agreement was to be applied to the present dispute. If I can be of no further assistance to the tribunal, if I may conclude and summarize my submissions.
Yes, please.
Thank you, Madam President. To conclude and summarize, it is the respondent's position that firstly, it is the law of Mediterranean that governs the arbitration agreement. Secondly, that the law of Mediterranean includes the CISG in governing the arbitration agreement since it falls within the scope of the CISG. And thirdly, that this arbitration agreement was not validly concluded and therefore the tribunal does not have the jurisdiction to hear and decide upon the present dispute. If I can be of no further assistance, I conclude my submissions here. Thank you.
Thank you. Any questions from the tribunal, or should we move to the claimant? No, okay. Would the claimant please take over?
Thank you, Madam President. Members of the tribunal, my name is Catherine Arnold. I appear as co-counsel for the claimant, LGUP PLC, and I will be dealing with the question of whether the parties validly agree to this tribunal's jurisdiction, which corresponds to question 1A in procedural order number 1. It's the claimant's overarching submission that the parties did validly agree to this tribunal's jurisdiction because they agreed to arbitrate under the terms of the arbitration clause contained in Article 9 of the claimant's general conditions of sale, and that they consented to arbitrate and thus to this tribunal's jurisdiction when that clause, along with the rest of the standard terms, were validly incorporated by reference into the parties' concluded contract in April 2020. The claimant will develop this submission by putting forward a positive case and an alternative case. Our positive case is, first, that the applicable law of the parties' arbitration agreement is the law of the seat, Danubian law. And second, that under Danubian general contract law, the arbitration clause was validly incorporated by reference into the parties' main contract. However, if the tribunal considers in the alternative that Mediterranean law, as the law governing the parties' main contract, should also be extended to the arbitration clause, in that case, the claimant submits first that the CISG should not be applied to the question of the arbitration clause's incorporation, and second, that under Mediterranean's non-harmonized domestic contract law, which is a verbatim adoption of the UNIDROIT principles, the arbitration clause was still validly included by reference into the parties' main contract. In either case, the claimant submits that the parties concluded a valid arbitration agreement and consented to this tribunal's jurisdiction over the substantive issues in dispute in these proceedings. Proceeding to the claimant's positive case, the claimant submits that the applicable law of any arbitration agreement between the parties is Danubian law, and that under Danubian general contract law, the parties validly concluded an arbitration agreement. We have two submissions to make on this point. First, the parties made an implied choice of Danubian law to govern their arbitration agreement. And second, that under Danubian general contract law, as I have already said, a valid arbitration agreement was formed when the arbitration clause was validly included by reference into the parties' main contract. Before turning to my submissions, I want to deal briefly with the respondent's point about the appropriate choice of law rules and tests to be applied in this tribunal's analysis of which applicable law should be extended to the arbitration clause. The claimant accepts entirely the respondent's submission that the tribunal should apply the choice of law rules in Article 5.1a of the New York Convention and Article 36 of the Model Law, and the three-stage test which can be derived from those provisions by academic commentators like Professor Gary Bourne and leading pro-arbitration jurisdictions in both common law countries like England and civil law jurisdictions like France. On the point of the model law, we would simply invite the tribunal to apply Danubian arbitration law, that is the model law with 2006 amendments in option 1 of Article 7. In this case, because it's the national arbitration law of the seat, the choice of law rule is enshrined in domestic law. And finally, given the model law's territoriality principle, and the fact that all 4 countries involved in this proceeding, Danubia, Mediterraneo, Equatoriana, and Mauritania, have all adopted the model law, any enforcement proceedings or proceedings for interim relief would have to be brought in Danubia because given the territoriality principle, proceedings under the model law can only be brought in the country where the arbitration is seated. So we accept the 3-stage test. We simply wanted to clarify further for the tribunal which national arbitration law they're applying here. Proceeding then to my first submission, which is that the parties made an implied choice of Danubian law to govern their arbitration clause when they expressly chose Danubia as the seat for their arbitration. The respondent has submitted that the tribunal should follow the United Kingdom Supreme Court landmark ruling in the recent case of Enka and find that the parties' express choice of law clause for their main contract also constitutes an implied choice of law for the arbitration agreement. In response, the claimant submits that while Enka is certainly an important case, it is perhaps not the most persuasive for this tribunal to follow, given that it is from a common law jurisdiction which has not adopted the model law in its entirety. The claimant submits that given that Danubia and Mediterraneo are civil law jurisdictions who have adopted the model law, it might be more appropriate for the tribunal to follow the approach of ICC tribunals and the French courts, a leading pro-arbitration civil jurisdiction, in finding that an express choice of law clause for the parties' main contract will not encompass the arbitration agreement and does not expressly or impliedly select the law applicable to the arbitration agreement.
Excuse me, may I interrupt and ask, are you stating that under the ICC rules of arbitration or its practices or policies that all arbitral tribunals operating under the ICC must reach that conclusion? And if so, what is your source for that statement?
Please excuse me, Ms. Arbitrator, I was not sufficiently clear in my reference to ICC tribunals. What I was referring to is that many ICC tribunals, particularly those seated in France, have taken this approach, but certainly not to say that there is binding procedural rule in the ICC that would require tribunals to go one way or the other on what the applicable law should be. So thank you for clarifying that point. The decisions ICC tribunals have reached are persuasive authority, but not, there's nothing in the ICC procedure itself. In any case, we would ask the tribunal to start from the approach of some ICC tribunals and the French courts, as, for example, in the recent case of Kebabchi and Koot Food Group, and find that the general presumption will be that the law of the seat should also be the applicable law for the arbitration agreement, unless the parties expressly state or provide substantial circumstantial evidence to the contrary. And that a choice of law clause for the main contract will not, in and of itself, be sufficient to displace the presumption that the law of the seat should also apply to the arbitration agreement. And I have 3 brief points to make about why in the present case, the parties have not expressly stated or given substantial circumstantial evidence that they wanted the law of Mediterraneo to apply to their contract. First, the parties did not expressly state that their arbitration clause should be governed by Mediterraneo law in their email correspondence. So for instance, if I could ask you to turn to page 17 of the record. This is Mr. Rain's email of the 9th of April. Among other things, he notes that the general conditions of sale will be included, the claimant's general conditions of sale will be included in the contract. And he reminds Ms. Bupati of what she had already been told at the Palm Oil Summit that, and I quote here, the sale will be governed by Mediterraneo law. Now, again, referring to French authorities, in particular Kebabchi, a broad reference to the sale is not sufficiently express to suggest that the parties intended the law of Mediterraneo to apply to the arbitration clause. They didn't say the law of Mediterraneo expressly governs the arbitration clause included in the general conditions. Second, based on the separability presumption, the fact that there's an express choice of law term contained in the arbitration clause, which states what the law of the parties' main contract should be, shouldn't be considered sufficient circumstantial evidence to establish that the parties wanted their arbitration clause to be governed by the law of Mediterranean. And this is because, according to the separability presumption, the arbitration clause should be considered as a separate ancillary contract. And third, it would make little commercial sense for the parties to subject an agreement whose principal purpose is to set out the procedures of the arbitral process to a different law from that of the arbitral seat, whose law will, of necessity, govern those same arbitral procedures. And furthermore, given that the parties in this instance were not legally trained, they weren't lawyers, they were business people, it seems reasonable to assume that when they selected Danubia as the seat of their arbitration, and it should be said for good reason, the claimant received advice that Danubia was a leading pro-arbitration jurisdiction, that they also assumed that Danubian law would govern their arbitration clause for the reason I've just said, the procedural nature of that clause. So for all of these reasons, the claimant submits that the parties made an implied choice of Danubian law when they expressly chose Danubia as the seat for their arbitration. And for this reason, we suggest that the first part of the choice of law rule contained in the model law at Article 36 and in the New York Convention at Article 5.1a is satisfied. There is indication that the parties made a choice of law to subject their arbitration clause to, and therefore there's no need to apply the default choice of law rule here. But we do note that in any case, the outcome would be the same because the default choice of law rule is to apply the law of the seat, in this case, Danubia. So wrapping up my positive case, then, we submit that under Danubian general contract law, the parties' arbitration agreement was validly formed because the arbitration clause was incorporated by reference into the parties' main contract. Danubian general arbitration law is an adaptation of the UNIDROIT principles, and it has a low substantive consent requirement, such that the inclusion of standard conditions into an existing contract requires a clear statement that such conditions are to be applied, but not that they are to be made available to the other party. In the present case, the claimant made several clear statements to the respondent that the general conditions of sale were to be applied. For instance, Mr. Rain confirmed this point in writing in his email of the 9th of April, to which I've already taken the tribunal, and the contract dated 8th of April likewise confirmed that the general conditions were to be included. Therefore, the arbitration clause was validly included by reference, and the parties have validly agreed to arbitrate. I'm conscious that I am running close to the end of my time. May I have one additional minute to briefly make my alternative case that under the law of Mediterranean, the parties still consented to arbitrate and to this tribunal's jurisdiction?
Yes, please, but try to keep it to 1 minute because we are running late.
Absolutely. Thank you, Madam President. So I have two submissions to make if the tribunal should consider that the law of Mediterranean extends to the arbitration clause as well as to the parties' main contract. First, the claimant submits that the tribunal should not apply the CISG to decide whether the arbitration clause was validly incorporated by reference, because the arbitration clause is not a sale of goods. The respondent has said that the arbitration clause will fall within the scope of the CISG, but the claimant submits that that may not be the right way to think about the problem. In fact, the claimant submits that the tribunal should consider whether the CISG's sphere of application extends to arbitration agreements. That is to say, arbitration agreements are separate ancillary contracts. They are not sales of goods, and therefore the CISG does not apply to the question of their formation. It only applies to the question of formation of sales contracts. Our second submission is that under Mediterranean's domestic non-harmonized contract law, the arbitration clause was validly incorporated by reference. Article 2.119 of that contract law states that standard terms contained in a separate document or electronic file will normally have to be referred to expressly by the party intending to use them. And this was the case here. As I have already said, Mr. Rain expressly referred to the general conditions of sale in his email of the 9th of April, as did the contract itself. Therefore, it's our submission that in either case, under Mediterranean law or preferably Danubian law, the parties validly consented to arbitrate under the terms of the arbitration clause, and therefore this tribunal has jurisdiction. Unless I can assist the tribunal any further, this concludes my submissions.
Thank you.
Thank you.
Do we have a rebuttal?
Indeed, Madam President, if I may begin.
Please.
Thank you, Madam President. We have 2 points of rebuttal with respect to the submissions made by the opposing counsel. First is with respect to the submission that the law of Danubia should be chosen as a result of it being the seat of arbitration. However, not at all points of time does the law of the seat of arbitration automatically have to apply to govern the arbitration agreement, since, as is the case in the instant proceedings, Danubia was chosen solely because it was a neutral venue and solely to ensure that the parties do not circumvent their international law obligations by way of their domestic laws. Secondly, with respect to the principle of separability cited by my opposing counsel, the principle of separability is limited only to make sure that the arbitration agreement remains valid if the contract itself is invalidated. Therefore, it cannot be used for all purposes, such as the determination of the choice of law to govern the arbitration agreement. With this, I conclude my rebuttals.
Thank you. Sir Rebuttal?
Thank you. Well, in reply to the respondent's first point that the law of the seat will not automatically apply, the claimant entirely accepts that point. However, the claimant, as discussed in our submissions, does suggest that the tribunal follow a variety of persuasive authority, that the general presumption should be that the law of the seat will also be the applicable law of the arbitration agreement, failing any express statement from the parties to the contrary or strong circumstantial evidence that such was their intention. And I would refer to the tribunal to my submissions that the claimant submits that in the present case, there was neither express statement nor circumstantial evidence to suggest that Mediterranean law should apply. Turning to the respondent's second point on separability, again, we certainly accept that separability is not for all purposes, although we would point out that there is a substantial variation across different jurisdictions on how broad the doctrine of separability should be. And were the tribunal to adopt the French approach, they should consider the arbitration agreement to be an entirely independent contract, but we're not necessarily advocating that here. What is really important is that separability applies when considering the validity of arbitration agreements, including the substantive validity of arbitration agreements. And so we say it's perfectly appropriate in this case for the tribunal to apply the doctrine of separability. Thank you.
Thank you. Any comments or questions from the tribunal? Well, I guess that ties us up. Thank you very much. You all kept very close to the time, which is good. And we're not supposed to give you any other feedback in this section, so we won't do so. If you want more feedback, please write to us. We'll be happy to comply. And I guess now we're supposed to go and discuss this, and I guess the administrators will move us where we're supposed to go. Thank you very much.
While we're
Thank
waiting, congratulations to all of you. You all did a wonderful job.
Thank you.
Yes, indeed.
Thank you very much.
And I'll tell you now, it's going to be very, very difficult to decide.
Thank you so
Thank you.
much. It was a great session. Sir, you were speaking. I'm sorry. So sorry to interrupt.
No, it's all right. I just wanted to congratulate both teams for speaking so well, presenting so well, and also fielding the questions well. Thank you so much.
Absolutely.
Now, since we have reached the end of the session, I would request you all to please keep your cameras turned on. And Tejas sir, if you can keep your camera, if you can turn on your camera, I'll just take a screenshot. Tejas sir, can you hear us? Okay, thank you, sir. Okay, I'm done. On behalf of the Asia Pacific WISP Pre-Moot organizing team, I would like to thank the arbitrators for their valuable contribution and time, and the teams for their participation. It was a great session. Thank you so much. And now, for the deliberation or discussion that the arbitrators might have, the teams can leave the room and join the link that is that Dakshita will put in the chat box. You can join that room and you will get to know, you will be further notified there. And as the teams leave, the arbitrators can carry on the discussion here.
Thank you, everyone. And you were all very terrific. And I wish you the best of luck in your journey to the final vise rounds.
Yeah, fantastic performance. All the best.
Thank you so much. Thank you for your time.
Oh, I was